Miss Jarana Bhattacharya, she wanted to have her own website, and she is Jarana, right? False. So she wanted to have a picture, very beautiful picture of Niagara Falls, and the developer rejected her idea and said, no, this Jharna in English, false. So she wanted to have that kind of photographs in her website first page. In website there are many photographs. You can, when you search photographs, it could be easily available in Google, right? But they are not uploaded to be used again by others for commercial purpose or other purpose. See, there are availability, but availability does not mean it could be used by others. Similarly, when you hand over certain creative things, then it doesn't mean that you hand over all the things. But if he gets that with certain terms and conditions, I can have every rights, then that is surrender of copyright. That is possible. For example, when a company, when a movie wins certain award on best movie or best music, that goes to producer, because producer get, this is the practice that they get approval from those creators, those directors or those composers as they surrender their commercial interest, but not moral. Moral is not transferred. Whatever terms and condition you have given to him, it is your painting. Painting by him, he cannot write that. Painting by me, he cannot write that. So there are certain things can be forwarded. There are certain things that cannot be forwarded. So in creation, moral, there are, in copyrights, there are two types of rights. One is industrial rights or commercial rights, or another is moral rights. Moral rights means reflecting your creator's name and those recognizing creators. That is one thing. In one case, there was one that was in public, so I don't mind sharing the fact. Mohan Bhusal produced one album, and one of song was written by a person who was not in Kathmandu, and that was published in Madhupark long ago. Madhupark or Gorkhapatra? Gorkhapatra Corporation was that, and that was that music, that song was given another credit in that level. So he came with complaint, and we had a meeting, and the only solution was that you withdraw whatever number of albums are there and replace with my name. Even I may not be interested on financial things, but give my name. See, this is very important. Moral rights is very important. Munamadan, written by Lakshmi Prasad Devkota, if Saja Prakashan has rights of reproducing that Munamadan, that doesn't mean that general manager of Saja Prakashan can write its his or her. So its moral rights cannot be transferred. You know, there is one movie, Sole, a Bollywood movie, and there is one interesting plot. The villain lives in jungle surrounded by big stones, and they have a particular structure of that thing, and that was very huge hit on its period. Then Ram Gopal Verma, another producer director, tried to revisit that movie, and later on he got complaint from original producer, and he wrote Ram Gopal Verma ki Aag, not even solely. So, but plots were similar. Name was not similar, not the same. Sometimes when you think about something, it's when it is general, then you will not get any protection. If you think something, and if you don't put that idea on paper, and in that case, then it is not protected. मैले सोचे थे, I thought about this before you cannot say like that. In software development, I have found some cases. We discussed these things in a meeting. Then before I start, he started his own product, and I need this intellectual property. Yes, you discussed, but you discussed on paper. You discussed on any email threads. You discussed on any other means of communications. No, if no, then that was very general idea. In general idea, you cannot get protection. How to cook kheer? How to cook pulao? It may not be, how to boil a water bottle. It's very generic. It's not protected. Baburam, Aaryal. There could be lots of people with the similar name. Even in our legal fraternity, I have seen two Baburam, Aaryal other than me. So these are not protected. What is protected? Something having significant presence came out from mind and written down, and came out in certain nature, I mean certain form. It should be there. And one important thing on this copyright is it's not necessary to register. This is very interesting for a creator. Creators are protected by natural law, not by any new legislative structure. Softwares, if it is a software program, then it's not necessary to register at registrar office of copyright. But when dispute comes, if it is already registered, then prima facie that is considered as original. If you prove your software is original with other inputs, then only you can exercise your software as your own original. I had one interesting case on this as well. So one of my clients came to me and asked me, they had one technical team that developed certain product, and they gave space for marketing company, and marketing company distributed that product, and always marketing company and client or end user had a contract between them. The original company who produced that, who created that software, was never in front. After 2 years, that marketing company developed the same software at another level, and had new level of contract with clients, and after that those original company was not getting any revenue, not getting any response from clients. Then they found that their software was already replaced. Okay, then let's complain according to the law. Let's challenge them at the court of law using Electronic Transaction Act on source code theft and copyright. And then I asked how equal those programs or those new software and your software. It's very equal. What about source code? They said no. They developed source code in 2 years drastically, and it seems they are using more advanced software, and we are weaker in that sense, and apparently it seems we are trying to copy their software. Interestingly, there was another problem on that case. That new marketing company had already registered that product at the registrar of copyrights. So in that case, new company had a strong base than the genuine company. Sometimes it happens. That's why, as I said, it is not necessary to register. Okay, that is there. But when you make a product, then I always suggest first go and register your copyright. That's very important thing. After establishing your as a genuine after challenge, it's very difficult. Before any challenge, if you establish yourself as a genuine, then it's very simpler to prove. So I already discussed about the patentability. It's very new. Novelty should be there, and it should be useful. Patent office might have certain limitations, as already I said. Certain type of commerciality that should be there. Some kind of practicability should be there. So there might be certain terms and conditions provided by a particular country's law. So it could be different from different country perspective. But the important thing is on patent side, novelty should be there. If it is novelty factor is not there, then your product is not protected under patent law. Another important thing is trademark. When you see certain logos, some brand, now Microsoft is a trademark. When Microsoft brings certain product, at least certain level of user, they start using that thing without any taste. That means it has created certain goodwill. So it might be symbol, logo, words, sound, color, design, or other device that is used to identify a business or product in commerce. It basically identifies business or company or organization or a product, basically, and that goes to the registrar. I mean, if it is not registered, then in that case it is not protected. See, there are certain symbols which you can find on any logos. For example, in Microsoft also there is R and one circle. Then R means registered trademark. If you use this R and if you are not registering, you have not registered so far, then you are misusing this legal protection. You cannot write this R without any without registering your product or your organization.
Baburamji, sorry to interrupt, but we just have 15 minutes.
Okay. So
I would like to hear more about the process of registering this patent right now. How to do that?
If we talk about software, then I'm saying it's rather than patent, it's copyright. For copyright, I'll just quickly. There are fair use as well. at the beginning, I started discussing about the exception, right? So sometimes there are certain clause, fair use by users. It depends on ways. For example, in university, students, they get copied books, certain chapters, and even in IT college, if you are in BE, first year or second year, if some teacher gives assignment to you, then all codes are not originals. You make a copy from others. That could be there. So from academic perspective or certain other perspective, there could be certain fair use exception. So while about registration process, while talking about the production mechanism in Nepal or around the world, basically there are certain copyright offices. In Nepal, we have registrar of copyrights, and you have to go to registrar office with your product. You have to give your all the details of your source code, and you have to compile your creative process, and you can seal that document, and you can hand over that to copyright registrar office. They'll have certain presentation as well. You have to prove your genuinity, you have to prove your originality, and in Nepal they have one committee. You present before that committee, and when the committee is with the opinion that your product is original, then they'll give you this certificate of copyright. In that case, there are some.
For intellectual property also is the same thing.
I'm talking about copyright software, because we are talking from this. Otherwise, the same process applies with other as well. If it is patent, then we have under Ministry of Industries, we have Department of Industries. In Department of Industries, we have intellectual property section, and intellectual property section, you have to submit your details. You have to fill up a form. They require certain things to be produced, and for industry, you have to be registered at industry, because if it is not registered under their system, then how they can give you certificate. So there are two level of registration at industry level. One is proper industry, Department of Industry, and another is small and cottage industries. Up to
this patent, intellectual property can be of anybody, not just industries. For an individual, if I build upon some idea.
I'm coming on that. And if it is your individual's claim, then it's on not commercial perspective. For example, we have trademark, we have service mark. For example, Olympic Committee, right? If Olympic Committee is having those 5 rings, and it should be protected, right? So for that, they have different categories, and if it is related with industry, then it has to be registered in that case.
So question and answer.
Yes, yeah.
So we have already started the question and answer session. So if you have any question, please feel free to write back, or you can just give your questions through this call. You take questions also specific that you want Baburam ji to address and everything.
So, what about the service oriented companies, how can their services?
You can register at the Department of Industries as service mark or service product. That is there. You follow most of the process similar, but there are certain categories of industries, service, hardcore industry, I mean production industries, and other things.
So once if I register for the trademark or the copyright, so if somebody copies that thing, so what will be the fine that he has to pay? Is there any limitations?
It depends on use of that trademark. For example, if
Once I heard that they have to pay only a minimum fee of 2,000 rupees.
it's not like that. It's you can challenge, you can claim damage, right? Damage, and damage are calculated in real term, not remote damage. It's your responsibility how much damage you suffered. For example, you have one product, and you are claiming that using my product's brand name by others is infringing my rights, and I lost certain things. Then it's your responsibility how much you lost, not imaginary actual loss. In some case, it's very difficult to calculate this intellectual property damage part. If you lost 50 packets of YYs, it's very easily calculated when it's stolen, right? But a software is source code is stolen, then it's very difficult to prove. One interesting case I would like to share. There was one case on source code theft, and the court said, with due respect to the court asked one of my clients, your main complaint is that you lost your source code. I mean, somebody stole your theft your source code, right? And my client said, yes or no. And then, can you use your source code even now? Yes, I can use those source code even now. Can you sell your software even you are claiming your source code is theft? Yes, I can sell my software even after this incident. Then court asks, you are saying everything is with you, then how you can say it's theft? How you can say it's stolen? Then it's totally different. Understanding theft of physical goods and theft of intellectual property is totally different, and it has to be calculated in totally different dynamics. So how many there is another case of copyright, that one short movie was sold in Germany through online platform, and there was complaint of violation of copyright of certain footage of another documentary, and there was a case in the court. Then I said, how to calculate damage? Try to track the number of clicks that sell or that number of clicks that platform got because of that product. How many clicks were there? That could be various things, but sometimes it's very abstract thing how to calculate the damage. It's very difficult in calculating damage in intellectual property. In some case, companies, they set certain fixed amount in their contract or their privacy policy or their policy, and they claim those amounts as a damage. But it's very difficult to calculate immediate damage in intellectual property thing. Anything?
So what if I bring some changes or innovation in others' design? Suppose I have this design, I have got the design of this cup, but I do not like the design. I modified it a little bit, and then I claim that it's my own design.
Whether this is just a modification or a new thing, it's very important. Modification means you are carrying originals, certain things. You cannot do like that. But there are certain things they leave certain space to you. For example, when you develop certain website, then people used to ask which platform you are using, .NET, C++, or something like that, right? They are giving certain space. Open source, they are giving certain space to you. If themselves, the product itself is giving certain space to modify you, then you can modify. Other than you cannot modify on that.
So up to what extent we can?
See, it's very difficult to determine up to what level. But if it is registered trademark or registered design, then it's very difficult to say. If it is registered design, you cannot. If it is registered design. There was one interesting case that I had in my early career. There was a case of design of wrapper of biscuits. There was Pashupati biscuits and Hulas biscuits, and Hulas was our client. And during the hearing day in Patun Appellate Court, in canteen, I asked a biscuit to eat myself, and I was Sprite, and I ate some 4-5 pieces of biscuits. Then I realized it's not Hulas. And then even in court, I raised that thing that even I am defending the same case, not able to identify the different companies' product, then how much suffer? There is no debate of copying design of that. Later on, I left that law firm, and then I don't know about the future of that case. But it was very interesting. There are lots of products having same Harpic, SARPIC and SARPIK. So it's very interesting that people are. So in that case, it's patent violation of copyrights, in apparent violation of intellectual property. It's like that.
So any questions? So we are just running out of time.
Yes.
If there is any question, you can just give a last question answer. Is there any question, Kiranji? So do you have any questions?
Just to wrap up on this, intellectual property has, as I said earlier, it gives rewards to the creator. So it is very important to protect, and while protecting certain your rights, you have to go through process as well. You have to cooperate those agencies who are protecting yourself. So don't be lousy and remain at office or home. Go to the office who are protecting you. That is very important. Most of the infringements are because of not taking any interest of protecting your rights in basically in copyrights or basically in software domain. There are very few software companies that have registered their softwares.
Basically, what kind of software needs to be this copyright?
Any kind of software. You can go to.
Basically, what is its implication? If I register that thing, then what is that sentence for me? Or
Sometimes what happens, for example, one of my client having finance software, they were working in Kathmandu, and somebody taken this source code and they were using in remote, let's say Kailali. You may not get idea about your idea is stolen sometimes. So even to protect, you brand yourself, you are registered, you communicate with that, and that gives a certain benefit to you. Then while selling your software, when you say this is copyright protected or copyright registered, then it gives more value to you, your product. It definitely gives more value to your product rather than just unregistered software. These days many companies are accepting those software only which are registered. Non-registered software are not accepted by certain clients, especially big clients or sensitive clients like banks and all these things. So it's very important to get the registration, even to add value of your product.
I think
By this we conclude. Thank you very much for listening me, and
I'm sure that you'll have some questions later on. Then what you can do is I can share you the contact details of Baburam.
so if you have any issue in future, you can contact me, and then my office is at Maithiga Circle, and it's very convenient place. You can come, and even if you are not my client, you can come to my place and
He's very
have.
friendly and he's very kind enough. Every time we call him, he's always definitely there to help the startups and everyone in the ecosystem. So thank you, Baburamji. We have a small token from Nepal to appreciate